Looks like we have everyone here. Welcome, counsel. We appreciate your willingness to appear in this format. Our case is Luna v. Luna. Just a couple of notes before we begin. It's usually helpful if you mute your microphone when not speaking. From time to time, we have technical difficulties. That's kind of to be expected, so don't let that worry you. If there is a problem, we'll simply take the time we need to remedy it. You might notice that we raise our hands occasionally. That's to signal to each other more than to you. For your part, if we begin to ask a question, we'd appreciate it if you would conclude that sentence and then immediately respond to the question. As you both may know, that while we allocate time for each of your arguments, in the event we are still asking questions, when your time runs, you may exceed your time. You need not ask permission. And in the case of the petitioner, Mr. Birch, should you go longer in your initial argument because we are asking questions, you will still retain all of your reply time. So with that preface, let me ask you to enter your appearances.
Daniel Birch for the petitioner.
Welcome, Mr. Birch.
Thank you, Mr. Chief Justice, members of the court. Joel Taylor for respondent Maria Luna.
Mr. Taylor, welcome. Okay, let's begin.
Mr. Chief Justice and members of the Supreme Court, counsel. A Rule 56 motion should properly relate to a, quote, essential factual element of a claim. I refer specifically to the Cochagrus opinion footnote 8, which ties very clearly into language that came originally from Celotex about essential elements of a claim. And the last sentence of footnote 8 says that a moving party can obtain summary judgment by showing or establishing that the non-moving party, quote, has not produced evidence on one of those elements, close quote. I stress the word element because I feel that's the biggest weakness in summary judgment practice generally, and specifically in this case. The focus that I'm sorry?
Sorry, I was muted. The clock has not started running. Sorry about that, Mr. Birch.
Okay, may I proceed?
Yes, please.
Okay. So I repeat that phrase over and over, essential element, because if the judicial microscope has too wide of a focus, then it loses its utility and it becomes difficult for the parties to properly make and respond to a motion for summary judgment. In this case, the motion for summary judgment ended up being on a very wide angle focus of negligence. Negligence as applied to a car crash case is very unsuited for summary judgment.
Could I ask you, could I interrupt here, Mr. Birch? Could you, I see this argument in your brief and I'm a little puzzled by it because looking at the motion for summary judgment, and it is identifying, seems to me, an element that there wasn't a breach of a duty, which is an element of a negligence claim. So I'm not understanding how your general concern relates to the way the motion was crafted.
So the motion itself related or relied on two things: the color of the light and the lack of an expert. And neither of those are elements. Now, breach of a duty, this is more relating to the Court of Appeals opinion. Breach of a duty, again, is too high of a level of a question. It incorporates too many other facts that would have to be brought into play, none of which individually is essential. And I contrast that, if I could, with Cochagrass, where a specific fact was notice of a defective pole. And I contrast again with Colissimo, where the specific factual elements were notice of defective wiring and notice of likely trespassing. And again, contrasting with Sallow v. Tyler, where the specific factual element was intent on both causes of action. So in each of those cases, we have a fact that is at a much more granular level than breach of a duty or existence of a duty or reasonable care. It's almost impossible for me to imagine how on a summary judgment motion you would flesh out an entire mosaic of evidence to relate to breach of a duty.
Well, not an entire mosaic, perhaps, but if a defendant comes forward under our SALO standard and says, look, here's the evidence in the record that I'm aware of that goes to whether there was a breach of a duty, whether Ms. Luna was operating the vehicle in a negligent manner below a standard of care, then where the plaintiff, the non-moving party, bears the burden of persuasion on that point, it is the onus at that point on the plaintiff to come forward with some evidence, maybe not the full mosaic, but at least some evidence to establish that there's a genuine issue of material fact. And I just don't see that you did that in response to the motion.
So Antonio's testimony was very clear. He had the green light. That was in opposition to the motion at the trial court level. And so in evaluating breach of duty, the moving papers, the motion itself didn't establish in any event that there was enough evidence to rule as a matter of law unless the non-moving party came forward with evidence. So that's what the Court of Appeals acknowledged, that the color of the
and endorse the Court of Appeals position on judicial admissions. You haven't carried your burden under SALO. The defendant came forward and said, look, here's the evidence in the record that I'm aware of, and I'm indicating that I'm carrying my initial burden of persuasion under Rule 56 of identifying what's in the record and asserting why I think that there's no genuine issue of material fact and I'm entitled to judgment as a matter of law. At that point, the burden shifts to you, to your client, to Mr. Luna. And if we reject your position with respect to on the judicial admission point and suggest that and conclude that he can't use Antonio's testimony, you have nothing, right? Unless I'm missing something. That's the only thing you advanced by way of evidence in response to that showing.
So even if Maria has the green light, that is not enough evidence to warrant on that record judgment as a matter of law. And I feel that places too little of a burden on the moving party for purposes of summary judgment. Let me just explain why that places an unfair limitation on the burden party.
Counsel, before before you do that, if I may, I'd like to have all of the facts in mind. And as I read things, and I'm eager for you to correct me if this is wrong, there are essentially three facts at play. That Maria had the green light. Okay, Maria so testifies, as does Lewis. Okay. Second fact, that Maria did nothing wrong, according to Lewis. And third fact, Antonio testifies he had the green light. Are there other facts at play?
Well, I'm going to disagree with the second fact. The Court of Appeals actually said that Luis's testimony that he didn't have any particular problem with Maria's driving was too uncertain and too vague to be a fact that could be relied upon. And I think it's an improper question in its form. It asks for an opinion of a lay witness on a sort of an ultimate issue, which is reasonable care. Luis could have been asked specific questions like, was she looking away? Was she on her cell phone? But at a high level of generality, to simply ask a very unsophisticated lay witness, do you have any problem with someone's driving? I don't feel that that's meeting the Rule 56 burden of a specific fact that a court should rely upon in granting summary judgment. But anyway, there were some other facts in the record.
Let me give you that and ask, is there anything else that is a candidate for a fact bearing upon Maria's negligence?
So
the record.
So as sort of collateral evidence that came in via the briefing on the color of the light, there is evidence that Antonio saw Maria approaching and reacted promptly. Maria had, she testified she didn't see Antonio till the last. And so you could infer from that that Antonio was in fact more alert and vigilant and reactive than Maria was.
Mr. Birch, I saw that, but that strikes me as entirely speculative. You were trying to glean from the fact that one driver saw it, that must mean, or it's a fair inference, that she was not as attentive. And this seems to highlight for me the distinction between a reasonable inference and pure speculation. Antonio saw Maria, therefore, and Maria didn't see Antonio or didn't testify she saw Antonio, therefore she was inattentive.
Antonio said he reacted promptly. His testimony was to the gist of he.
I read it. I'm saying that seems to me, help me understand why that's a reasonable inference versus pure speculation.
Well, Antonio's testimony was that he saw her and hit his brakes. And he testifies to those in factual sequence. Maria doesn't testify that she saw Antonio and took any reactive measures. So I guess I would say.
I apologize. Mr. Birch, there wasn't anything preventing your client from submitting an affidavit saying, I'd like to supplement my deposition testimony and indicate that, I recall that Maria was inattentive or, looked at her phone or something. And you didn't put in anything like that. So that's another problem from my perspective.
So this is what I have a problem with, is that when you respond to a motion for summary judgment, you're responding to a specific argument. And I feel like it's unfair to expect the non-moving party to go beyond the specific factual assertions and start filling in a record on things that were never raised. You have no notice, particularly that those are going to be argued down the road as somehow essential elements. Reaction time, it's not a specific essential element of a claim. It's just part of the whole story that each person tells.
Breach of a duty of care is, and that was exactly the point of the motion for summary judgment. I mean, I'm missing something about your position, unless your position is you don't like the SALO standard, which I think is sort of ultimately what you're saying.
SALO referred to a specific factual element, which was intent. And there was a complete record on the issue of intent. Now, if there was not a complete record on the issue of intent, then my opinion, the proper course is to say the record is incomplete and inadequate to allow judgment as a matter of law, so the moving party bears the risk at that point of an incomplete record. I might suggest that's what happened in Cochagros. There were two defendants that did not get out on summary judgment, and it was on the basis of there wasn't enough factual record to warrant a judgment as a matter of law. And again, breach of duty is just too high level. It encompasses too many considerations to be a useful level at which.
I mean, it is the level. I mean, it's the element of the claim that you've asserted. I must still be missing something. What kind of standard would you have us adopt? What limitation would you have us place on the SALO standard that it applies only to certain kinds of elements, and elements of some claims that are at too high of a level of generality, you don't apply SALO? I don't understand this. And what support would you have if that is what you're asking us to do?
So that is my argument, is that if you're calling an element of a claim something like breach of duty, it's Rule 56 talks in terms of specific factual assertions, certain material facts that then from those facts warrant a judgment as a matter of law. If you come in at the level of the elements of a claim that aren't specific facts, then it's really unworkable at the trial as an advocate. I mean, and let me just say the moving party here simply asserted the color of the light. And so, Rule 56 only requires you to respond to the facts that are asserted that warrant judgment as a matter of law. Now, if the rule that comes out of this case is you have to go beyond that and go beyond the asserted facts in the motion and put on a mini trial, let me just suggest a couple of reasons why that would be a very difficult standard. Because a lot of...
I still think it's a mini trial. I think it's some evidence,
Right.
Enough evidence such that a reasonable jury on this element could rule in your client's favor. I think you got a real uphill battle here. I don't know of any court, we essentially endorse the Celotex standard in SALO, and I don't know of any federal case, certainly don't know of a Utah Supreme Court case that has said, when we talk about what, how Celotex works, it's only some elements of some claims where the burden of persuasion dictates who has to come forward with evidence. And you didn't come forward with any evidence. I don't know where we would get this standard. You say that it's in Rule 56. I don't see it there. Rule 56 says moving party comes forward and says no genuine issue of material fact, entitled judgment as a matter of law. How do we know which facts are material? Well, we look to the elements of claims. The element here is breach of a duty. I realize I'm just saying the same thing, but I think I must be confused about your argument, because I don't know how we would even write an opinion that would say what you're asking us to say.
So Rule 56 requires the moving party to assert material facts that warrant judgment as a matter of law. That's
not what it says. Go ahead, Dino.
You are, sorry, right?
I was looking for my Rule 56.
You're okay. But they've claimed, they've identified in the record why they think there is no material issue of fact, right? and they've pointed to it. Your response could be as simple as the light was in fact red, or green, whatever you want it to be. It makes no difference. Or you could say, in addition to that, it makes no difference because Maria was also negligent for the additional reason. But the initial burden has been met. They've pointed to the record and why they claim that you don't meet that particular element. You're not somehow at that point forgiven from raising other arguments in support of why you have met the element if your argument is rejected. If the one you do make is rejected.
Well, a fact is the color of the light.
Right. So if I say there is no evidence my client breached, and I point to the record testimony that says the light was the light was green, right?
Okay. And
that's the only thing that you choose to fight about. And you don't choose to put on any other evidence of negligence. You don't win if you lose on that particular factual fight. You don't win somehow, despite that fact, because there might have been another negligence argument that you didn't raise. And that seems to be kind of what you're doing with these other facts. This notion that perhaps she didn't react quite as rapidly based on the fact that he reacted.
Well, let me loop back to Rule 56 again. It has to be an undisputed material fact. And Rule 56 says, and that fact, the asserted fact, not putting any other burden on the non-moving party. The asserted fact entitles the moving party to judgment as a matter of law. And if the asserted fact does not entitle the moving party to judgment as a matter of law, Rule 56 hasn't been met. That's the literal language of Rule 56.
Justice Lee, Mr. Birch, that you are upending our case law, and that really seems to be what you're arguing for.
Well, I'm arguing Rule 56 as a genuine issue of material fact, and that fact entitles to judgment as a matter of law.
I understand. I'm sorry, Chief. Go ahead.
Well, no,
I'm done.
Well, as I understand your argument, Mr. Birch, it is that they have merely asserted that the light was green. That fact standing alone does not warrant summary judgment because there may be other factors that could play into negligence, the ultimate question. And that turns on your discounting Lewis's testimony that she did nothing wrong. You've done so with the argument that is at too high a level of generality, right? But if that is not the case, then Maria has presented evidence not just that the light was green, but other evidence, which may be less persuasive based on its general nature. But it seems to me it's nevertheless evidence that is fairly recognized in making the summary judgment assessment. So, in other words, I think that Lewis has asserted not just that Maria has asserted not just that she had a green light, but additional testimony from Lewis that she didn't do anything wrong. And you've met the green light question with your evidence from Antonio, but I don't know that you've presented other evidence contradicting Maria's evidence about what Lewis said. Is that what's unfair about that view?
Well, the Court of Appeals did not go down that road. They said that testimony from Lewis was not sufficient to be any kind of a judicial admission. I argue it's not even admissible to just ask a lay witness, do you have any problem with someone's driving?
Well, they did consider it an evidentiary admission, right? And that's what turned the case in the Court of Appeals. They had the judicial admission on the light and an evidentiary admission with respect to whether she did anything wrong.
I didn't read it that way. I apologize. If I'm wrong in the way I read it, I would submit it.
I could be wrong as well, but that's how I read the opinion.
I read the Court of Appeals as not adopting the evidentiary admission approach of California. And of course, this segues us into judicial admission, where these are just evidentiary issues for the consideration of the trier of fact rather than affording it a sort of preclusive effect.
Yeah, maybe you could be right on that. I'm confident, of course, that the Court of Appeals concluded the light color was a judicial admission. I mean, you argued that was wrong. They may not have labeled Lewis's testimony an evidentiary admission, but they did conclude that it was determinative in the analysis, that the light color alone didn't get Maria to summary judgment, but that taken together with Lewis's testimony, which they assigned weight to, it did. And so it seems to me your argument then turns on the idea that Lewis's testimony was altogether inadmissible and entitled to no weight because not sufficiently specific. Is that accurate?
I don't have any problem with her driving. I would say that is an inadmissible question and answer. It's just too general, and it calls for an opinion couched in a to a lay person.
So I understood the record and the Court of Appeals opinion a little bit differently. I didn't think it was that the I don't have a problem plus the color of the light is sufficient to establish summary judgment. It's that it's sufficient under SALO to shift the burden to your client to come forward with some material evidence. And if that's the only evidence in the record, then maybe this isn't materially different from what the Chief Justice just said.
You're right, Tom, exactly.
That's exactly right.
So I'm just saying again, Rule 56 requires two things. Number one, undisputed material facts, and number two, that entitle the moving party to judgment as a matter of law. And until the moving party establishes that, then the burden under Rule 56 doesn't shift.
Mr. Birch, so respectfully, it seems to me you're just completely upending SALO in our case law by that articulation.
I wanted to ask you something about judicial admission. So the Court of Appeals really relied on some policy reasons for choosing one alternative over the other. When you look at the different ways that courts have handled this. And one that I'm having a little bit of trouble with from your side, if we go with the way you'd like to look at it, is just treat this as any other evidence, is that when it is the plaintiff, when it's the party, and I realize this always applies to the party, but you have a party almost saying, instead of alleging that the defendant actually is liable or was negligent, the plaintiff is basically alleging, well, I don't know if they were negligent, but this other person says they were, which just seems strange if we're just looking at policy reasons for going in one direction or another, to have a plaintiff who's supporting a claim not by anything they think or they saw, but saying, look, I'm bringing this suit. I don't know that she did anything wrong, but someone else says that she did. Can you respond to that just from a policy perspective? Oh, we might have lost. Did you hear me? You started circling there for a minute.
You all circled on me, I have to say. So
okay.
I think I get the gist of it. So this is a common scenario. Plaintiff sues D1, says D1 caused my injury. D1 says, oh, it wasn't me, it was D2. Now, under the Luna opinion, plaintiff can't say, well, okay, it's D1 or D2 and sue both of them. Plaintiff is bound by the original allegation that it was D1. That just seems profoundly unfair to me. Plaintiffs can be wrong. I mean, they're typically wrong about all kinds of things. Speeds, times, distances, medical history, what the doctor said to them. I mean, part of the skill of an attorney is knowing when and how to impeach your own client's testimony, because clients are wrong a lot of times, and maybe the jury believes D1. You know.
I was thinking about that. Certainly, you might have a situation, and this might be one of them, where things happened really quickly. Your client was almost immediately knocked unconscious. And so he doesn't know exactly everything that happened. And maybe you could come up with other evidence beyond what he saw that could, make you the prevailing party at trial. How would that, if we're looking for a rule that will apply across the board, though, does that always work in different type of cases? It seems like, for example, maybe in an emotional distress case, if the it doesn't seem to apply across the board neatly. Do we, if we do follow the rule that you want us to follow, are there ways that we need to cabinet? Are there limitations? Or are you just asking across the board, no matter the kind of case, just treat the plaintiff's allegations as evidence equal to anybody else's?
Well, I can't offhand think of a scenario where I would cabinet, but there could be. But I would say that for sure in car crash cases or other, like a product liability claim, who knows? The plaintiff may sue one person, D1, and then through discovery or through a Rule 9 allocation of fault or however, be put on notice that D1 says it's someone else or an unknown party or whatever. In tort cases specifically, it just seems like a really unwise rule to me.
The question I have on judicial admissions, Mr. Birch, is this. It certainly seems to me that there are circumstances where someone might be equivocal about the color of a traffic light. And so I get that concern, but why isn't the response to that? Well, we have opportunities for parties to take back what they said in a deposition and to explain why the testimony they gave in their deposition is now, in their view, either mistaken or merits some qualification. That didn't happen here. Instead, your client testified repeatedly in his deposition that he very clearly that the light was green. Said that several times. And in response to the motion for summary judgment, there's no affidavit saying, I've thought about it some more and now I'm not so sure. So that seems like a problem for me.
So this loops. So the short answer there is that the role of kind of walking back that factual testimony is counsel as advocate rather than the witness saying, "Oh wait, I've had a change of mind. Now I don't remember clearly what color the light was." That would be perjurious, and I would not suggest that to any client. But it's certainly counsel's obligation to walk those back and to encourage the jury to look at other evidence.
Why is it perjury? I mean, it's not always perjury for a witness to say, I've thought about it some more. I mean, it might be difficult. You might not want to do it. And it might be dishonest. But if it's honest, I don't understand why it would be perjury to say, yes, I said it then, but I've thought about it some more. And in fact, I'm not so sure that the light was green. And in fact, if your client isn't willing to say that, then this particular concern in the Doctrine of Judicial Admissions about, a witness could have been wrong or could have been mistaken or could have been in a situation where there's some equivocation, I just don't think has any salience. If the witness isn't willing to come in and say, yeah, I might have been mistaken, let me explain why my view was obstructed or whatever.
So if Luis now says, yeah, maybe I was mistaken, his memory is still what it is. And so to change that would be not honest. Sorry.
I guess here's sort of the best case scenario for you, and what I think this is what I think is a good argument for your position.
I'll make
Let's say, let's say in this situation, Luis, he thought the light was green. I mean, to this day, his memory is, I thought it was green. That's what I thought I saw. But then you find you hit the jackpot and you have Antonio's testimony, another bystander who can say, no, she came speeding through a red light. And then you've got maybe a traffic camera that shows her speeding through a red light and looking down at her phone. Should you be precluded from bringing all that other information that shows Lewis's memory is faulty or what he thought was faulty? He still thinks he saw a green light, but clearly my client was wrong, and all of this other evidence shows she was negligent. That's sort of the question.
Well, I faced this a long time ago in Gaw versus State of Utah. Faye Gaw thought she was turning into a protected merge lane in an intersection, and she said repeatedly, she was very adamant, I'm not confused, I was never confused, but the factual evidence was that in fact she was very confused, and she turned into a through lane where a truck driver ran her car over. Now, I had to go to trial. I had to tell the jury, she's wrong. She sincerely, subjectively did not feel confused at all, but she was just wrong. And so that's a counsel level thing to walk back or to place a client's erroneous testimony in proper context. That's an attorney level thing. And I don't think, personally, I would not ask a client to walk back and say, now that my attorney has explained to me, all this stuff, now I'm just not willing to do that. But as an advocate, I'm certainly comfortable saying my client is simply wrong about this point because look at this other evidence. And that's what I did here. I pointed to Antonio. Antonio was, in my opinion, a very believable witness.
You just have to determine whether you think you still make out the elements based on all the evidence, fitting your own client's testimony in as sort of a puzzle piece and figuring out, why does my client think this? Okay, actually they're wrong, but we still have a claim.
You could argue to the jury that, look, my client is a very credible person. Knowing that this might hurt her case or his case sticks by X. But those aren't the facts. For the following reasons, Antonio's testimony is far more credible. One of the things it seems to me that the Court of Appeals may have really missed is the swiftly moving event exception. And one of the things that the appellee really doesn't deal with at all. It seems like it's kind of custom made for the running the light situation where things happen so rapidly, and because of human nature, we know that there are just a lot of people are really convinced that the light is red and the light is green, and somebody's wrong. Somebody's wrong, and it's not because they're lying. It's because of the underlying factual circumstance that McCormick lays out in the third rule contains this exception. So it may be the case that the judicial admission rule is an excellent rule and should be incorporated. But I'm really concerned about incorporating it without recognizing the validity of the swiftly moving event exception.
Thank you. I can't add anything more to that argument. So, but it's true. If you look carefully at Luis's testimony, he really isn't that clear. He doesn't remember how long the light was green.
He's clear. I wouldn't go there. He does get knocked unconscious pretty rapidly, and he is trying to walk it back. To me, in all candor, Mr. Birch, this case rises and falls on whether the court is going to adopt the swiftly moving event limitation on judicial admissions, right?
Okay. And I
may be wrong. I'm only speaking for myself, but I think that that's really the crux of this entire matter.
And I certainly endorse the swiftly moving event exception. If those of us that deal with traffic crashes on a daily basis, people's memories of these things are just often very wrong. It's like crimes that suddenly happen, the witness says, oh, it was something, something, but under the stress of an event, we all know what happens. It's their mind coming back after the fact, reconstructing what they think they remember. And the physical evidence or other witnesses can be very different. So I think this is a classic case where the nature of the factual dispute does not lend itself to judicial admission. A contract case,
I don't understand. I'm sorry to interrupt you, but I don't understand why we would have a blanket rule on swiftly moving events. I mean, wouldn't that just be a factor, a consideration to take into account? And I mean, here again, we've got unequivocal, repeated statement that the traffic light was green. I mean, I accept that under some circumstances, swiftly moving events might lead to equivocation. But I mean, isn't the key whether it's something that was perceived by the witness and whether the witness said something conclusive?
Well, this backs me up to a broader philosophical difficulty I have with the Luna opinion. The color of the light is an objective fact that exists independently of any subjective memory of any of the witnesses. And so if we arbitrarily exclude Antonio's testimony and solely focus on Luis's subjective recollection, I feel like we're missing the forest for a tree. I think we should determine the objective reality of what happened by incorporating all relevant evidence. There's no argument that Antonio's testimony was not relevant or admissible. And so that's just a basic philosophical difference I have with the judicial admission doctrine, going beyond just the simple acknowledgement that these are just facts for the fact finder to take into account in determining what really happened.
Right. I won't belabor the point. I'll wait for opposing counsel.
Yes, let's conclude your opening,
Thank you.
Mr. Birch, and move to Mr. Taylor.
Thank you, Mr. Chief Justice. Members of the court, may it please the court. This court should, excuse me.
Mr. Taylor, I'm going to start you off with the statement that I made to Mr. Birch, because to me, it really is the heart of the case. In your brief, you punted on the swiftly moving event exception, essentially, seems to me.
Well, the swiftly moving exception.
That's probably not fair. I think you cited the North Carolina case, but there are a lot of authorities from around the country that say this is not the kind of case in which the judicial admission doctrine should be applied, and that this is effectively courts commenting on the evidence to apply it in this setting.
I would suggest that that exception is but one factor to consider when you are considering the testimony given by Mr. Luna. For example, he testified repeatedly.
Under McCormick's third formulation, it's not a factor, it is an element, isn't it?
Under that factor, it says it can be an exception if a court is inclined to do so. However, it does take into account in what the Court of Appeals discussed that their four-part standard provides those factors to suggest that the swiftly moving exception is not necessarily.
I just don't get it. I can see that this individual is absolutely certain the light was green, but he can easily have been wrong in this setting. It just is a matter of human nature. We know in these events that can happen. He's not willing to perjure himself, right? He's not saying I'm equivocal because he's testifying honestly. But there could be 3 eyewitnesses. There could be a tape out there. There could be all kinds of evidence, right? Not discovered maybe at this point in time, but in your world, this case, because this person is unwilling to lie, the case goes away. Now, he's got to point to something. I agree with that. But he does. Unequivocal testimony that the light was red on the other side. And we're creating a perverse incentive for people to fudge the facts here in this kind of setting. And I'm concerned about it, and I'm concerned about the policy about courts commenting on the evidence. You know, what are the just a fundamental concern I have.
In response to that, I would suggest that we also have the testimony from Maria. Maria testified consistently with Lewis that the light was green, that they had the right of way. So that's part of the record.
It's not on summary judgment. It's not that whoever has the most votes wins. Right. I think there's a really good reason why the swiftly moving event exception exists, because it recognizes reality and human nature, and it doesn't incentivize questionable or manipulated testimony to avoid summary judgment.
Well, the swiftly moving exception for purposes of this case would not necessarily apply because of how certain Lewis was, specifically about the color of the light. He may have indicated that he wasn't clear or he didn't know other questions asked, but on that specific issue.
I want to piggyback off of that and just add something by way of at least the way I'm thinking about this. I don't think it's quite right to say that this formulation under McCormick is a swiftly moving event exception. It's the exception is whether the testimony is something that relates to a matter as to which the party could easily have been mistaken, and then it says such as a swiftly moving event preceding a collision. To me, the key there is could easily have been mistaken, and I'm just not sure. This kind of goes back to one of the last things I said to Mr. Birch. I'm not entirely sure that it makes sense to do this on a categorical basis. This seems to me to sort of go to do we have a case in front of us in which there is equivocation? And to just make one other point and then let you jump back in. It seems to me that what judicial admissions are about is not establishing objective truth. It's about establishing whether we have a meaningful dispute on a material fact between the plaintiff and the defendant. And where the plaintiff and the defendant both agree, to let the plaintiff sort of go forward and try to contradict his own testimony, I just think it's not good use of judicial resources. I think that's the policy.
Please respond to Justice Lee. I'm just putting my place in line after your answer.
I would agree with that assessment, and the Court of Appeals pointed that out in their fourth element of the judicial admission test, when it says if the parties do not actually have a dispute about a particular issue, there seems little point in bringing the power of the judicial system to weigh in on the matter. And then it goes further. It seems like there's something unjust allowing a litigant to convene a trial so that a jury can determine if the facts are other than what they've already sworn that they are. So in this.
Well, let me give you a hypothetical to test that a little bit and see if you can help me out with it. And it's the traffic camera hypothetical.
Okay.
So tell me what policy would support if a plaintiff genuinely believes their honest testimony is that the light was green when they entered, but a traffic camera unambiguously shows that it's red. So why in that situation wouldn't we allow that to be assessed on summary judgment? Why wouldn't we allow that to create a genuine issue of material fact when you have something that contradicts the plaintiff's testimony so plainly?
Well, presumably in that situation, that information or that video of the traffic would have come out during the course of discovery, and it would have been known to the parties prior to the filing of a motion for summary judgment, which would potentially create an issue of material fact as to the breach of the duty.
Well, but if I understand the way the Court of Appeals articulated the judicial admission doctrine, if the plaintiff testifies honestly and says, I believe it was red, or I believe it was green, even though the traffic camera shows that it was red, that you can't use that traffic camera at that point. You're stuck with the admission.
Well, at that point, there would be some equivocation in the record that they could cite
but it's not equivocation in the record, as I understand it. It's equivocation in the testimony. The deposition testimony is unequivocal, but it's contradicted by objective evidence to the contrary. Now, if I understand the way Justice Lee was testing Mr. Brecht on this, he said, well, perhaps the plaintiff could go in and amend the deposition testimony and say something like, well, you know, I still believe it's this way, but now I've seen this video evidence, and so that causes me to believe that maybe it might be contrary. But that seems to me like it might be a little bit of form over substance at that point. So just help me understand the policy of tagging a plaintiff with something, holding them to it, not allowing them to contradict it with objective evidence to the contrary.
Well, I think that would go to the second element that the Court of Appeals set forth, where the testimony at that particular point would not necessarily be clear, and there would be some ambiguity about it as it relates to the other evidence. And at that point, opposing counsel could introduce and allow a witness to testify and see that video, and then provide some additional testimony about what the traffic camera showed at that point.
But you have that other evidence here. You have Antonio's testimony. So if I understand your point, you would concede you lose if it were a video, but you insist that you win because it's another recipient witness. I don't get that distinction.
Well, I think the distinction would be that it is some sort of physical evidence or objective evidence that you are able to observe, rather than your memory that you are testifying about the facts of the loss.
So if there were three other witnesses, that would be enough for you then?
Three other witnesses to
the accident that said the light was red. Even though Luis said it's green, three other witnesses, not Antonio, said it was red. That would be enough?
Well, in this particular situation,
that's hypothetical.
Potentially no, Your Honor, but in response...
Okay, so no, that would then, Luis would still lose.
Luis would lose in terms of that would be insufficient to establish... Three independent witnesses view this and say, no, the light was red. It's under your understanding of the Court of Appeals opinion, Luis would still lose and should still lose. No, because there would be additional facts in the record that could be cited to.
There are additional facts right now. It's called Antonio's testimony.
I understand that, but Antonio's testimony, in terms of what he says, is based on his perception as a driver. Now, in looking at that as it relates, that's the only other fact, is what I'm trying to...
You're describing, counsel, it seems to me you're describing the evidentiary admission doctrine. I mean, I think as Justice Pierce points out, the judicial admission doctrine means it cannot be rebutted. We don't care about other evidence. If you are clear, and if Lewis is absolutely clear and unequivocal, then we say, end of game. Cannot be rebutted. All other evidence is irrelevant. On the other hand, the evidentiary admission doctrine says, well, you get a presumption, but we'll look to that traffic camera, or we'll look to those three other witnesses. And so under your scenario, or under your in your perception, how would you describe the judicial admission doctrine?
I would describe the judicial admission doctrine as repeated, unequivocal testimony that is under oath that was personally observed by the plaintiff.
And what is the consequence of that?
The consequence of that is that at trial, the color of the traffic light would be uncontested. It would be green for purposes of Maria driving through. Now, that's also considering the additional facts of the case. For purposes of this case, those are all the facts we have. And in so this situation, we wouldn't have a traffic camera. We wouldn't have 3 additional witnesses. So it would be a case-by-case basis where a plaintiff would testify unequivocally, repeatedly, under oath, about an issue within his personal knowledge. And then it goes into the policy reasons for permitting a judicial admission to exist, in that if the parties don't necessarily agree on the facts of the loss, there shouldn't be a need to convene a trial to be able to establish facts that are otherwise.
Could I interrupt here on this traffic cam example? I want to ask you about what I think is maybe the second formulation according to McCormick, which is that the question testified to has to be within the peculiar knowledge of the witness or of the party. Have you looked at the cases on that? Do you know what peculiar means? And, you know, if there's traffic cam evidence, would we say, well, that's not within the peculiar knowledge of this witness?
Right. So going into the peculiar knowledge of the witness, it would be that there is objective evidence otherwise to show that there are facts to establish that this may not necessarily be a judicial admission. And that's where I go back to it being a case-by-case basis.
I'm really asking if you know how the case law interprets peculiar and what that means.
Peculiar means, sorry, go ahead.
I've understood it to be personal observed testimony.
Now, doesn't peculiar mean things that only you would know, like your motive? And isn't that why McCormick criticized it? Because he said you're just as likely to be wrong about your motive and your intent as you are about observable phenomenon.
So in other words, testifying that peculiar knowledge is only a statement of fact that you can testify to and nobody else.
Right, and that others cannot, peculiar to you. And McCormick's pushback to that was, and the cases, and you tell me if I'm wrong, that's a faulty breakdown, because you're just as likely to be mistaken about your memory, your individual memory that's unique to you, or your intent, your motive, those factors.
Yes, I think some cases have stated that. The cases I have reviewed also include personal knowledge that includes objective facts observed by a party under the second approach formulated by McCormick. Now, one thing about the McCormick different tests is they all essentially end up in the same place. They're not necessarily different in that they ultimately come to the same conclusion that when you have a case such as this, where there is relatively little evidence in the record about the traffic light, we're only dealing with parties to the lawsuit, that a judicial admission would be created when a plaintiff and a defendant agree, so long as it.
Could I jump in? Could I jump in here? I'm troubled by the traffic cam hypothetical as well. And, you know, one possible answer to it is, well, that maybe that's just almost every time you'd expect the plaintiff to retract the testimony and you know, in the face of the traffic cam. But I don't know how satisfying that is. If we had that kind of a case, here's my question. The Court of Appeals opinion has a series of factors that are taken from McCormick, and then there's this sort of catch-all thing at the end that I don't have it in front of me, but it's something to the effect that, or, you know, if there are circumstances in which the policies of the judicial admission doctrine are not fulfilled, then maybe the judicial admission doctrine doesn't kick in. And I don't know exactly how that would play out or what that would mean, and I don't know whether we ought to adopt it, but, you know, maybe that's a way to deal with the traffic cam hypothetical. Another would be to just say, maybe the exception judicial admission doctrine just only applies when what you're talking about is plaintiff perceived it one way, defendant perceived it another way. And in those circumstances, we have a judicial policy. If that's the only evidence, then we have a judicial policy that says, look, if you as a plaintiff are unequivocal, it's just not a good use of judicial resources where you and the defendant both agree.
Yes, Your Honor. And in the third test for McCormick, it states this rule often comes with a number of qualifications and exceptions. For example, a party is free to contradict and thus correct his or her own testimony. If there is a traffic cam, there would be the ability to potentially correct or contradict that testimony by way of an affidavit or something of that along those lines.
No, that would just say I was wrong. I mean, you really are trying to incentivize people in light of other evidence to manipulate their testimony. The person honestly believes the light is green. He shouldn't be incentivized to change his testimony. Under the policy considerations Justice Lee just let out, we would still, in case of the traffic cam, we would still invoke the judicial admission doctrine then. You know, in this case where Maria says it's green and Luis says it's green, it wouldn't matter. And I think that there's a fundamental truth-seeking function here in recognizing in events like this, in fast-moving events, parties can be mistaken about the color of the light, right? And that's why this isn't the situation. There may be others, but this is not the situation in which the judicial admission doctrine should come into play.
I would respectfully disagree with that assessment, Your Honor, based on the totality of the facts and the testimony given by Lewis in relation to looking at the
totality. You may be right at trial. But on summary judgment, the totality right now includes uncontradicted testimony from another witness, a percipient witness who said the light was red.
Well, that's where under McCormick you would have additional qualifications and exceptions to the judicial admission rule.
Be clear, under McCormick says there should not be such a thing as a judicial admission exception, right? McCormick advocates for let the jurors weigh the testimony. If we're looking at his the scholarly independent assessment, they're recognizing these other exceptions, but they don't think that's the preferred exception.
Well, McCormick sets forth those three tests. The Court of Appeals adopted the third. Under the third test in McCormick, they talk about qualifications and exceptions to that specific test. Now, if there are one of those exceptions could be a swiftly moving event. But in reviewing the testimony from Lewis in the record that was submitted on summary judgment, you'll see that for other questions such as distance and time as it relates to where the loss occurred, he says he doesn't know or he says he doesn't recall. But he is entirely consistent repeatedly over the course of two depositions separated by several weeks that the color of the light was green. And based on that unequivocal testimony that was under oath, that was made in the course of a judicial proceeding, it is consistent with the policy set forth by the Court of Appeals that we should not convene a trial to determine facts that are different than what the litigant says they are. In other words, at this point, it seems that we're playing fast and loose with the facts after Arias settles out of the case. And now we want to get to a place where there's two parties left. And I acknowledge we can still call Arias to testify about his facts of the accident. But in this particular situation, on the issue of the color of the light, the facts and testimony provided by Lewis are such that it should constitute a judicial admission because it meets the four-part test of the Utah Court of Appeals and because it meets the third test set forth in McCormick. When you look at the totality of his testimony, it's not just one question, what color was the light? He repeated it over and over and over. There were 7 different instances where he said, well, I don't know how far away we were from the intersection, but I can tell you the light was green. And based on that analysis, when we're looking at the repeated, unequivocal nature of it, there seems to be little purpose in bringing the case to a trial to try to walk that back and then make the case better now that we have areas settled out of the case. Thank you for the opportunity to argue this morning, and I will submit that this court should affirm the trial court and should affirm the Utah Court of Appeals. Thank you.
May I proceed? Sorry.
Thank you, Mr. Taylor. Mr. Birch.
Thank you. So, I'm just unwilling to in any way coach or suggest that a client walk back what is sincerely believed to be their testimony. I view it my job as counsel to place their testimony in the proper context, but I'm just unwilling to have Luis do that as just a fact lay witness. I guess that's kind of my final answer on that subject. I want to go back to the summary judgment standard burden question, and I want to pose a hypothetical, and it goes like this. Instead of Maria moving for summary judgment on the ground that she had a green light, suppose she moved for summary judgment with the material fact that she had a green car. Now, clearly that doesn't entitle her to any sort of summary judgment. But what if I don't oppose that? What if I say, you know what? That does not entitle you to judgment as a matter of law, so I'm not even going to bring in a witness that said you had a red car.
That's an immaterial fact of the law. That fact has nothing to do with any of the elements. So I don't see where this is going to get you.
It's insufficient to warrant judgment as a matter of law. And that's my argument.
Because the fact in question in your hypothetical is an immaterial one. The facts here are clearly material.
Well, I would say it has to be more than just material. It has to entitle the moving party to judgment as a matter of law. That's Rule 56. And if I could quote more on that point, it's my reply brief, page 19. Moore's federal practice says the party opposing summary judgment is not required to anticipate and respond to potential grounds for summary judgment that were not raised by the movement. And that's my biggest objection, is that I don't think it's helpful to have us speculating what other facts may have been raised and rebut them in a vacuum. Now, the dividing line here, I suggest respectfully, and I mean that sincerely. I have enormous respect for the court, but I think the dividing line here has to be that between a claim and a factual element. And breach of duty is not an essential element. That is not a factual element in the same way that constructive notice is, or in the same way that intent is. Intent is a factual element of a claim, whereas breach of duty is a very high level order of claim. If I could just follow up on that with a comment about how this plays into pretrial procedure. And the point I would make here is that discovery, pretrial discovery, is primarily for the benefit of preparing for trial and not creating some record for summary judgment. There are any number of reasons why depositions are not taken. Proportionality, tier restrictions, and a very important one is this. There are many witnesses that I'm expert witnesses locally that I'm very familiar with, and I have no desire to depose them or ask for a report to give them a dry run of what my cross-examination at trial will be. And for cost reasons and for trial strategy reasons, I often greatly prefer to go to trial without forcing an expert to do their homework or without giving a defendant a dry run of my cross-examination. And so when a summary judgment motion comes along after fact and expert witness discovery is over and there's nothing in the record on a material issue, then it's very unfair to require either the court to open up discovery again or to say, well, too bad, you should have guessed or anticipated that a motion might be made later and you should have done discovery differently. I think that if there's an incomplete record, the risk of losing summary judgment should fall on the moving party, as it did in Cochagris, where duty, which is an essential element of a negligence claim, duty was not sufficiently briefed or factually put into the record to a degree that allowed the court to rule as a matter of law. So the court just said, remand, we're not going to rule on that as an alternative ground. So, and you might wonder, for example, in this case, why did I put the entire deposition of this treating surgeon in the record? Well, because I'm thinking, well, wait a minute, I don't want the Court of Appeals to affirm on the alternate ground that I didn't establish facts for causation and damages, even though they were never raised in any fashion in the motion. And so what you end up doing as counsel, you start trying to put in prophylactically entire depositions on the chance that down the road, someone's going to say, well, you didn't put on your prima facie case. So it's a more efficient use of judicial resources to place that burden in the initial instance on the moving party to specify what the moving party feels are dispositive material facts, and not to turn summary judgment into some sort of dry run, because like I said, for any number of reasons, that evidence may not be in the record. It may not be easily available. The vast bulk of tort cases are actually under $25,000 kind of cases. I mean, if you start running out and deposing doctors and experts, you could win your case and go in the hole. And so, I would urge you to look at the entire litigation process as you think about how to set out standards for summary judgment. I think Moore's hits it exactly right. I think that if you put the burden of putting notice on the moving party, then I know what I'm responding to. But if it's just the color of the green light, which is not sufficient, just like the color of the car, not sufficient for summary judgment, I don't like to have to be guessing what else I should put in.
So the position that you just talked about, do you think that contradicts Celotex and Salo?
Not at all.
How do you think it does not contradict those?
Celotex, the specific fact was, if I remember correctly, was exposure to asbestos. And that's a fact. It's a fact that is part of the claim. It's essential. And the record was complete. I think the concurrence in Celotex was quite clear that the record was complete on that factual issue. And so, and Salo, the record was complete. That was a motive kind of a case where the intent of the acting parties was the relevant thing, and there just wasn't a lot beyond the testimony of the parties and some documents, but the record was complete. And so I'm fully supporting Salo. Colissimo, same thing. The plaintiff had to prove notice of defective wiring. Again, there are so many notice cases that have been decided by summary judgment. I'm not opposing any of those. If you come forward and say on that specific issue, notice of a hazard, okay, now, and as a plaintiff, I know I've got to hit that issue. So, and then Cochagris was the same kind of a thing. So no, I'm not opposing any of these cases at all. But if you say breach of duty, if Colissimo, they said, oh, you didn't prove attractive nuisance. Well, all those sub-elements that are contained within that cause of action, that's more of the granular level that summary judgment can effectively be done without these other unfortunate consequences. My time's up unless there's any other questions. I appreciate the court's consideration.
Thank you, Mr. Birch, and thank you, Mr. Taylor. We appreciate your arguments, and we will take this matter under advisement. Court is adjourned.